There used to be, I can look at that. And all Mocha used to look it up, if they didn't want. I can call off.
Are we gonna have a hearing where they're sitting at their tables or not?
Yeah, they'll be at the tables.
You're talking about this?
Excuse me. Cindy. You talking about that? Are you talking about this?
No, I'm looking for the other little one. I stuck it somewhere because I sat on it. Mr. Wolf?
Hi, your client can't go to inpatient treatment because she's not eligible because she has open cases.
Okay.
So if y'all want to discuss time and agree to a time for her to be sentenced for an amount of time, because there's nothing else the court can do.
May I suggest something?
Sure.
Postpone sentencing until the state either decides to proceed on those cases or not.
No.
It's sad, it's just not enough. It's not gonna do it.
How much credit this?
Give me 1 second. Longer. No, but that's. Sorry.
I stuck it right here
Okay.
on this thing.
I'm not participating.
You're not participating in this?
I'm just here for. I'll still put it on.
You're killing me. You're doing this on the shots, right?
You don't see the other polls, right? What about from other counties and see that on there? It should, but it doesn't. I don't see it. So it should. They need to find that.
mediator Darrell Harris. I am requesting. Courthouse with the kid.
Mr. Wolf, are you all ready?
Yes.
All right.
What is the?
All right, court is calling 2022 CR 11622, State versus Jennifer Amber Hernandez. Can I have parties announced for the record for the state, for the defense?
Warren Wolf and Ms. Hernandez.
All right, so the court was not aware of certain things about this case before the court gave you your options. One, the court was not made aware that you had two open pending cases. So what I can tell you is this: because you have two open felony cases, no inpatient treatment facility will accept you. So have you all reached an agreement on anything else, counsel?
Yes,
All right, and
defer to the prosecutor.
state.
Adjudicating guilt, assess punishment at 6 months of confinement.
All right, so what they're requesting now is that they're asking that the court rescinds its previous ruling and that you be sentenced to 180 days in the state jail facility. Do you understand?
Yes, ma'am.
Have you had an opportunity to discuss that with your attorney?
Yes, ma'am.
All right, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal? All right, and defense, if you could for me, please.
I did fill out.
Let me see if I have it.
I checked with the amount of days she has credit. She has 174 days. She owes him 6.
All right, counsel. All right, then what the court will do, the court is finding violation of condition number 4 true. The court will follow your agreement, grant the motion, revoke, find you guilty, and sentence you to 6 months in the state jail facility. Give you credit for any time served. I'll recommend the therapeutic community. And let me see if there's any restitution. Probation, do you know if any restitution was ever requested from the complainant?
Your Honor,
Yes,
just out of curiosity, how long will it take for her to be transferred to the state jail facility to serve those 6 days?
you'll have to contact the sheriff's office and ask them. Or either the
Because
quickest way to ask is to ask an inmate. I always tell people inmates can tell you how long it takes to transfer. And they can also tell you how much time they're actually doing on parole. Those are the only two things that inmates are responsible for. But just a second. Yes. All right, and there's to be no contact with Rosalinda Chantaka, Chantaca. And there's $1,000 fine. Time and money will run concurrently. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. So with regards to these other two cases, the harassment and the assault on the peace officer, state, when are you expecting for that to be properly investigated to see whether or not it's going to be indicted, or are they going to be rejected?
I don't know when they'll be indicted, but I seriously doubt they would be rejected, Your Honor.
All right. So,
Your Honor, I apologize for interrupting. As a practical matter, perhaps it might be better to sentence under 1244A.
no, I will not be doing that. She hasn't reported since 2023. So here's my next question. With regards to these two other cases, again, they'll probably hold her at the jail because it's going to show these two cases are open before they transfer her to the state jail facility. We're going to recall these two cases. State, you all need to make a decision on whether or not you're going to seek indictment or not. I don't know how the system is run upstairs, who is over whether or not these cases are indicted, which prosecutor it will be. But we're going to call this back. And counsel, you're able to be here January 19th?
Yes,
All right,
let me check the date, just to make sure.
we can do the 16th, the 17th, or the 19th. That'll give the state a whole week to decide whether or not these cases, they're going to be seeking for it to be indicted. Officer Shilley,
Yes, Your Honor.
thank you so much for coming this morning, and thank you for zooming back in this afternoon.
Of course.
All right.
You said January 19th, it's some.
No, December 19th,
December 9th.
or we can do the 16th, the 17th, the 19th. Or the 20th.
19th.
All right, Norma, if you'll recall her back for December 19th, at that time, the state will let the court know what their plans are with these other two cases. Otherwise, you're still going to be in limbo. You understand? All right, thank you.
May I be excused?
Yes. All right, Norma, and who's the other attorney for the other inmate? Can you call them?
Well. It is.
And Mr. Wolf, you may want to coordinate with Judge Nahara's court, because that's supposed to be the court where you're supposed to obtain discovery. So you may want to check with Ms. Ferguson as well to see if these cases are on the docket there or not.
Is there a setting date in Judge Nahara's court?
You'll have to ask the coordinator. I don't know off the top of my head.
But if you don't have jurisdiction over those cases,
That's not necessarily true.
it's in Judge Nahara's.
Not necessarily, because she has this open case, the felony. That's why these other two cases, they just brought them here. But what I'm saying is they have a process down there, and maybe their process may be quicker as far as discovery, or maybe if you go through them, maybe the state will be quicker in determining whether or not they're going to seek to hold your client over for trial. Yep, there you go. No settings. All right, thank you.
See you on the 19th. I don't see you center. And you. Happy holidays.
All right, Marco, here's this one.
Thank you, Judge.
And then I'll put these two in the system.
Yeah.
Okay, I sent an email to all the judges in the entire courthouse about missing gloves. All right, so I'm now getting a response back from everyone.
He never found them.
No,
We never found one.
Gloves. Gloves.
Who is,
Are
we
we
never
allowed?
found his gloves.
yes.
Mhm. Have you seen?
It is not.
Schedule's really nice. That's freedom of calendar.
All right, court is calling 2019 CR 10230, State of Texas versus RC Curtis. Can I have parties announced for the record for the state?
Darrell Harris with State Yard,
Steven Spear for the state.
and also Miss Alexandra Bogus.
And also who?
Alexandria,
Bogus.
I
All right.
apologize for my mispronunciation.
All right, so you all can't be walking around and whispering because the court reporter is taking down everything that everyone is saying. For the defense?
Charles Bond for Mr. Curtis. Ms. Shaw is present, but she is not present as appointed counsel, but she is present.
All right. And are you Mr. Curtis?
Yes, ma'am.
All right, we're scheduled today for jury trial. Mr. Bunk, I am aware that you're waiting for, please be seated.
Okay.
I am aware that you're waiting for a verdict on the trial and the 226, so
Yes,
the court
Judge,
is
and the
aware of
jury
that.
Deliberating.
So other than that, are the parties ready for trial?
Yes, Your Honor, the state stands ready. I do know the defense. has
Well, no.
issued-
State, are you ready for trial?
The state is ready for trial, subject to trial motions that are in the court file that I'd like to urge.
What pretrial motions?
Number one, state has filed a motion with the court to fingerprint the defendant for identity purposes. If I get approval, I am coordinating to have an examiner come from the record section of the sheriff's office as we speak.
All right, so here's my question with regards to the motion for the state to fingerprint Mr. Curtis. Has he been fingerprinted before?
Yes, Your Honor, when he was initially printed, when he was arrested on this matter in November.
No, I mean for jury trial.
Yes, Your Honor, his appearance has also drastically changed in the.
No, my question, I just have a simple question. Because I'm trying to figure out whether or not I should grant this. And let me just tell everybody where I'm going. During the first trial, if he wasn't fingerprinted during that first trial, then somebody needs to explain to me why he should be fingerprinted now. So my question is, during the first trial that he had that ended in a mistrial, was he previously fingerprinted?
No, he had not.
All right, so why are we here with this late date to fingerprint him?
Because in the years since the initial booking and the mistrial, the defendant's physical demeanor and appearance has changed drastically to wit. At the time he was booked, he was 6'2", 345 pounds. The gentleman sitting at the defense table now, our visual inspection appears to be under 200 pounds. Witnesses who had identified him then may not recognize him. There may be, I'm just trying to cover my bases to have him fingerprinted. I have his booking photo and the prints taken originally. They have been filed with the court.
So and I'm just trying to understand. Oh, please, everyone, please be
Yes, ma'am.
seated. It's easier for the court reporter to hear. It's easier for me to concentrate. What I'm trying to figure out is this. You say that witnesses may come and cannot identify him because he's changed in appearance. I don't understand how getting his fingerprints transfers to a witness. For example, if a lay witness were to come in, I don't see how having a fingerprint is going to help a lay witness identify them unless that lay witness is a fingerprint expert to say, I see these fingerprints and they are the same. I don't understand.
I'm simply trying to ensure the state can prove up the identity of the defendant and have that evidence in front of the court. This was my method, knowing the demonstrable changes in the defendant's appearance. I'm trying to accomplish that with the tools available to me.
All right, defense.
We object to the motion.
All right, what's your grounds for objection? Please remain seated.
Sorry, just have it, we'll have it. I agree with the, I don't see how, as I understand fingerprinting process, you have an expert fingerprint, then compare them to some records, and that expert testifies that the person he took the fingerprints from is the same person that matched the records. How that's transferred to a lay witness, I don't see how a fingerprint expert would be relevant to a lay witness's in-court identification.
That's the court's question.
If I may respond, Your Honor.
Yes.
And again, as the court has posed the question, no, that would not be transferred to a lay witness. But if there is any ambiguity or indecision, we expect to then put on the evidence of the examiner who would say, I printed the person sitting in the defendant's chair. I compared those prints to the prints of one R.C. Curtis with a booking slip who was booked in November of 2015 on the arrest for this cause. And then that is my intent to clear up any potential ambiguity as to who, and the witnesses will identify him from pictures and media at the time that led to the indictment, but I am simply trying to shore up my case, again, given his demonstrably different physical appearance.
All right, with regards to the state's motion, one, I don't understand why, because this case has been pending for a long time because there was a mistrial. I don't understand why in year 2023 a fingerprint wasn't requested at that time.
Because the defendant never physically appeared, he appeared virtually by Zoom.
Oh, if you all wanted a fingerprint, you could have filed a motion at that time. He was appearing by Zoom because you all were saying, we're just here to get dates. But if anybody wanted a motion and wanted fingerprints done, then I would have ordered him to be here and not be by Zoom. And he was by Zoom at the agreement of both parties. I believe the state agreed that he could appear by Zoom. The defense had no objection to their client appearing by Zoom. Am I incorrect?
We didn't object.
And I understand the court's recollection, but at the time when we all agreed, all parties knew there would be a point in time in the future when the defendant would physically be present. So while we agreed then, we did so knowing there would be a future date when all would be available. Had I known that there would not be a chance at that future date, then I would have objected and insisted on the defendant's appearance at one of those other occasions or settings.
I don't see how the fingerprints of the defendants at this point in time is relevant to this trial. If at some point in time it becomes relevant, then I will reconsider allowing the fingerprint to happen. But I don't understand how fingerprinting him helps with identification of lay witnesses or of identification of officers. All right, what's next?
And the state has also attended with this case. There's another witness who's in custody in the Kerrville County Jail. Donald Barnett filed a motion for the court to issue a bench warrant to have the sheriff of the Bexar County bring him here for anticipated testimony later on in this trial, this matter.
All right, so again, why is a bench warrant just being done today? If we were supposed to have jury trial today and selection of a jury, I don't understand why. I mean, I will sign it, but if this person is not here for the trial, then they're not here for the trial. I'm not going to let this trial continue just to wait for a witness to be bench warranted. So the court will sign it. And defense is the state's witness. So defense, yes, thank you.
And the final matter, Judge, the court has already signed a motion to release property in the custody of district clerk back to the court, signed that on 8 November. We have initiated the necessary coordination with the district clerk. It is physically in the district clerk's office in this building today. I would simply like to discuss the logistics of bringing the evidence back to the custody of the court reporter so we can proceed.
Just one moment. Then you can coordinate with them with regards to that. Anything else?
Nothing else other than state journal.
All right. Is he here?
I'm trying to check.
All right. Defense.
Okay, on behalf of Mr. Curtis. As the court is aware, we've had some discovery struggles, to be generous in my word selection. One of which led to the mistrial, which led to the appeals, which led to the significant delay in the trial. The court more than one time made a statement similar to the following. The defense better have all of the evidence. And every time the court was answered with, they do. We have triple checked. Everything is there. November 20, now fast forward from those meetings and those conversations between the court, myself, and the state to this last November 22nd, roughly 3 weeks ago. I'm at lunch. I get a phone call from the state. We found a new phone dump. A new Cellbrite extraction has been found. Less than 2 weeks. So here we are, set for trial again. After the delays caused by primarily the first time they found a phone dump in the middle of a lunch I had. I will tell the court that the Cellbrite extraction is from the phone of the deceased. It's now, in fairness, part of the contents of the Cellbrite extraction were on e-discovery. In other words, if you take, for example, Lindsay's phone, and you do a Cellbrite extraction, and part of that is text messages. And so if you Xeroxed 20 text messages or 200 text messages and put those in e-discovery, that part of the Cellbrite is on e-discovery, those text messages, but the rest of the Cellbrite extraction is not. That's what's happened in this case. Somebody, and I believe it to be Detective Hines or Sergeant Rackley, took things from this woman's phone, put it in e-discovery, however, failed to disclose to anyone else that there were 300 or 400 other pages of Cellbrite extracted discovery present on the, as I understand it to be, on the server of the San Antonio Police Department since then, that had never been disclosed to the defense until November the 22nd. The court may or may not recall that in the original trial, Detective Hines was asked by defense, did you do a Cellbrite extraction on this woman's phone? The answer was, I don't remember. So as much as it pains Mr. Curtis and myself to say this, I don't think at this point I can announce that I'm ready to proceed because, again, I'm handcuffed by this tactic of let's wait till the last minute and see what else SAPD might have and then give it to them.
All right, just one moment. State, what's your response?
That counsel is generally accurate, extracts reports from the entire extraction had been disclosed and had been made available. Also, as I reviewed what's in discovery, there was a notice of additional discovery for a phone data dump when we pick up that had also been there. These documents have been available since March of 2016.
All right, the March 2016.
Yes, ma'am.
Is that what the defense counsel is referring to?
Yes, ma'am. As to other phrasings that counsel made, the court may recall on the original mistrial, this Cellbrite report extraction is referred to throughout the prosecution guide, etc. It is simply the entirety of the report that was on servers at the department that was not discovered to include through the previous
All
mistrial.
right, let's talk about this.
Yes,
Let's
ma'am.
talk about
Yes, ma'am.
what the defense is saying they do not have or did not receive.
Yes, ma'am.
I'm assuming, defense, that you received this information on November 22nd, 2024.
I received an email from the state. I believe it was later that afternoon, yes.
All right. And the entire extraction, when did you receive that?
I believe it was in the email I received that afternoon,
So November 22nd.
yes.
So here's my question. Why did it take till November 22nd for this to be given to the defense?
Your Honor, my only answer is that day, November 22nd, 1 hour before the email, I proceeded with a phone call to defense counsel. That is when I learned of its existence.
Well, this is what the court is going to do about that. If it turns out that that extraction, the new extraction, is inculpatory, you're not using it. Now, how long would it take, and what's on this extraction? How many pages is it?
472 total, Your Honor.
472.
All right, we can go off the record. This is what I fail to understand. This case has been on the docket forever. This case was brought to me from another court where it had just sat around, and it was brought to the court in 2019. Here it is, 2024, and discovery is still not given in its entirety. This case, there was a mistrial because the defense didn't get the discovery. And now we're back here for a discovery. I don't understand why everyone is waiting to the last minute to accomplish things. I don't understand why a detective is just turning over data at the last minute where we're here for trial in December. Can anybody explain that to me?
I cannot.
Do I need to have state every witness that you plan on calling? Do I need for us to come into court and have the defense here with your client, and you're here with your witness, and both of you all ask the witness questions about discovery to make sure everybody has it? Is that what needs to be done? So I'm assuming Detective Hines is the person who knows about all the evidence in this case. Is that correct?
Yes, Your Honor.
So this is what we're going to do. We are coming back on Friday. Detective Hines will be here on Friday. You all are going to get a chance to question him. And state, the questioning of the defense is not going to be allowed to preclude him from appearing, saying that he's unavailable and he's already been crossed, because he's going to be brought here and everybody's going to talk to him and make sure that there's every piece of discovery that he has is turned over. Does everybody understand? He will be here on Friday at 9 a.m. And then after he comes here, guess what? After the holidays are over, we're going to come back every week. And every week we're going to come here and we're going to see if there's more discovery that hasn't been turned over. We're going to make it every Friday. We're going to come in here and the question is going to be asked, is there more discovery?
Yes, Judge.
So I will see everybody on Friday.
Yes, Judge.
And Mr. Curtis, you will have to be here on Friday. Is there anything else?
Not on behalf of Mr. Curtis. It would be excused until Friday morning at 9 o'clock.
Yes, Norma. If you tell Norma to give him a reset form for Friday. Thank you. Is there anything else
Not
from
on
either
behalf-
side?
Oh, yeah.
All right, have him here on Friday.
May I approach?
Yes.
Good afternoon, Judge.
Good afternoon. How's it going?
This motion pretty good, pretty good. Trying to finish off the week strong.
Wow. Well, everybody's trying to have their Christmas parties or whatever they're doing.
Oh, yeah, I
It's
know.
all right to make everything.
Hopefully it doesn't make more work for the rest. of the
But
system.
yes.
Thank you, Judge. Appreciate you.
All right, thank you.
In the matrix.